In this lecture, we're going to discuss a little more about the key elements, key points of the Indian Gaming Regulatory Act that would play out over the course of time and become instrumental both as problems and as leverage and assistance to the tribes in pursuing their goals of obtaining a more luxurious, if you will, or more valuable level of gaming and Class III gaming through the tribal state compacts. First of all, it's clear that Congress enwrapped this act around the federal policy of self-determination, self-sufficiency that was intended for tribes. They made it very clear that the passage of the act was done in this vein. In addition to that, we understand that Congress has expressed that one of the significant and primary purposes for this act is to ensure that there would be an appropriate regulatory activity involved in the oversight of gaming to ensure the fairness of the games both for the patrons and for the tribes itself. We know that Congress has expressed that the purpose truly of Indian gaming under this act is to promote economic development, to promote self-sufficiency of the tribes and strong tribal governments. Clearly in the past, the federal government understands that tribal governments have by and large been funded by funds that come from the federal government through various federal programs. To get away from that dependence upon those federal program monies for actually running their tribes, a large economic boost was necessary. Congress saw gaming as the only thing on the horizon that might fulfill that need. We've discussed before the classifications of the games that Congress designed into the act, and today I want to get into some of the other key elements. One of the first things we need to discuss is who is eligible to conduct gaming under the Indian Gaming Regulatory Act. The answer to that question is that Congress very clearly expressed its intent that only those tribes that could meet a certain criteria. That criteria basically is tribes that are federally recognized. That leaves the question of what happens to those tribes that have, for instance, state recognition but not federal recognition. And it's unfortunate to have to say that because of the way Congress designed this and the definition it applied to an eligible tribe, it's clear they did not intend for those tribes to take part in gaming under this act. What we really see here is Congress pointing towards a political relationship or a political status of a tribal government as being the entity that would qualify and be eligible to conduct gaming and to fall under the umbrella of the Indian Gaming Regulatory Act. As a result of that, I think it's pretty clear that unless those tribes that presently do not have federal recognition can achieve it, they will not enjoy the fruits of the Gaming Act. A second key term under IGRA is the definition of Indian lands. Now, those of you that have studied federal Indian law in some depth understand that Congress has, for a very long time, typically used the term Indian country when it intended to express its will by law on something that would be within the jurisdiction of a tribe and that would be outside the bounds of state jurisdiction, for instance. The term Indian country is a term that was defined under the criminal statutes, Title 18, in approximately 1948, I believe, under Section 1151. That definition essentially says this: Indian country is recognized as being reservations, as being restricted allotments and trust lands, and as being dependent Indian communities. Now, the use of the term Indian lands has caused some confusion and brought about some litigation in certain quarters. So it still remains to be seen exactly what Congress intended, although the National Indian Gaming Commission has exercised its authority as the regulatory agency to interpret that pretty much along the lines of the Indian country definition. A couple of controversies that arose over the issue of Indian lands that might be worth discussing lightly. One was the Christiani allotment in Kansas, where the Miami tribe discovered sometime, I want to say in the late 80s, that there was an allotment that had been granted to a minor back in the time when Kansas was still the home of the Miami tribe. Within that reservation boundaries, like many of the tribes, their lands were being taken and allotted to individuals who wished to accept allotments and stay behind. The balance of those lands, the surplus lands, would then be opened for settlement. The tribe discovered that there was still a piece of land up there that had never been probated from the death of that minor allottee. In a long drawn-out process that I'll not try to explain in full, the tribe went through an exercise of trying to claim that land within its jurisdiction and authority in order to build a gaming facility on that property. There was litigation that followed. Eventually, the tribe lost that battle. I think that the machinations they went through to try to establish their authority over that land did not seem to sell to the court, and eventually they lost their desire to game on that property. The second more recent event occurred here in Oklahoma, just outside Tulsa. A couple of years ago, one of the traditional Creek tribal towns, the Kyligi tribal town, attempted to build a casino on a restricted allotment of a couple of members of the Creek Nation. The issue that came up there was, is that truly the Indian lands that Congress intended for the use for gaming by the Kyligi tribal town? Now understand that the tribal towns from the old Creek Confederation, there are still 3 of them that have survived. Kyligi is one of those, and they have their own federal recognition apart from the federal recognition enjoyed by the Creek Nation of Oklahoma. The allotment that they attempted to build on, though, was an allotment that had been granted to an individual Creek Nation member at that period before statehood, and had been passed down, inherited by the family. What the courts found and what the National Indian Gaming Commission determined was that Indian lands, it references the Indian lands of a particular tribe. In other words, the fact that this was a restricted allotment of a Creek Nation member and not a Kyligi member was a critical point. We understand that the tribal towns also enjoy a dual membership. They have membership in their tribal towns and in the Creek Nation. But they would have received individual allotments that could be traced back to their particular town or settlement areas. And in this case, it was not a Kyligi restricted allotment, and thus the tribal town lost their opportunity on that particular property. Congress has expressed that tribes will have the exclusive proprietary interest in any gaming that takes place on Indian country. We know that has become a big issue of late as the National Indian Gaming Commission has continued to find new applications for the term sole proprietary interest. But the true intent, I believe, from Congress was that the tribe would always be the owner and operator of those facilities. They clearly granted the tribe the right to bring in outside talent and knowledge and expertise because they have arranged this process by which tribes could engage through a management agreement that kind of talent and skill that could assist them in the operation of their gaming facility. The other issues that have come up along those lines are the application of the sole proprietary interest policy or view to other kinds of agreements, be they lease agreements, consulting agreements. And those continue to be a bit of a problem as I feel like the sole proprietary interest view has been taken to a very minute detail. I believe what Congress intended was to make sure that the tribe was the one that owned the property, that owned the facility, and was in control of the facility, and that they received the dominant share of the revenue from that gaming operation. Now we know that tribes can engage in gaming now under this act as long as they're in a state that has permitted such gaming by any person for any purpose. Now that language has been the key language that has been contested in litigation all over the country ever since the passage of this act. We understand that in Class 2, what tribes have to be able to find is that the state has in some way authorized the operation of gaming, be it charity gaming or commercial gaming. Once we know that bingo, for instance, is legal within a state's jurisdiction and in any way or some way is being regulated, then the tribe is entitled also to operate bingo. The tribe may operate bingo, however, under its own set of regulations and not necessarily be constrained by the kinds of limitations that the state might have placed on their regulated games. For Class 3 gaming, we get into a whole new discussion. In the beginning, we all felt that Congress had dealt with all three classes of gaming in the same fashion under the spirit of the Cabazon decision, which basically had held that tribes were the sole sovereign authority over gaming within their territories. We know that in the act, Congress went to great detail to place certain constraints and requirements on the tribe, and I'm going to discuss with you now a few of those to talk about some of the highlights or lowlights, if you will, of what Congress required of tribes within the framework of the act. First of all, before a tribe can conduct gaming, be it Class 2 or Class 3, the tribe has to act legislatively. It has to pass a law, ordinance, code, whatever that tribe might call their legislation, that authorizes the conduct of either Class 2 or both Class 2 and Class 3 gaming. Under that law, the tribe must set up a process or a vehicle by which it can conduct background investigations and issue license. Now, the licensing issue will stretch all the way from the licensing of a management company right down to the licensing of key employees within the facility. For instance, those that are working in the bank or have access to the cash. Congress also spoke to the use of gaming revenues. And it goes back to their stated purpose and intent, the intent of economic development opportunity, the intent of funding and providing for self-determination and self-sufficiency. So what Congress designed as the proper uses for the revenues from tribal gaming pretty much stuck to that course. First of all, the tribes can use those funds to fund government operations. Secondly, they can use those funds to pay per capita payments. They can also provide for the general welfare of the tribes, which I believe is interrelated with the per cap payment authorization, should they choose to go that direction. But they can also continue to use that money to promote economic development. They can also use the money to make donations to charitable organizations and also to assist in funding the needs of certain local municipal county government activities. In Oklahoma, we would generally see that as what the tribes have done all over the state in terms of providing additional roads and highways and bridge monies for a lot of counties, but also in providing certain things like fire trucks and police cars for law enforcement and fire departments out in the rural areas, which are pretty much pressed for the funds to provide that themselves. Congress also saw that it was necessary to require tribes to conduct annual audits of their gaming facilities. Now, these annual audits can be conducted either as independent, separate audits that the tribe conducts on their gaming facilities, or those audits can be encompassed within the broader audit of the whole tribal entity itself, the tribal government. Tribal governments annually have to provide audits as a response to their contract funds under the various federal programs. So as a part of that overall audit, many times tribes will also slide in there the audit of their gaming facility, make it a part of that overall exercise. In addition, when tribes are planning to construct gaming facilities, tribes have to go through an exercise of assuring that there will not be violation of certain environmental protection provisions. And so they have to involve the analysis of the environmental impact of their construction on the land and be able to produce an assessment of that impact. In addition to that, tribes have to ensure that the construction of the facility will be performed or carried out under some construction code, local or national, in order to assure the welfare and safety of the general public that might be visiting that facility and rely on that quality of construction for their safety. Finally, Congress saw fit to provide for enforcement of the criminal violations of the Act. We know that we already have the Johnson Act, 1166, which involves the interstate transportation of gambling devices. But in addition to that, Congress saw fit to ensure that violations of the Act itself would be prosecuted by the Department of Justice and federal courts. They did that by incorporating certain state laws, certain state criminal laws, and providing for the prosecution of the violation of those crimes if violated in the process or on the property of gaming in the gaming facilities. In our next lecture, we will begin discussions of Class 3 gaming and the process by which tribes can engage in Class 3 gaming through the negotiation of compacts with their states.